Hello, welcome to Mentoring with the Masters. My name is Jennifer Kuyrkendall. I'm the Third Circuit representative for the Young Lawyers Division Board of Governors. Today I have the privilege of speaking with Jamie Moses of Fisher Rushmer. She is a board-certified appellate attorney here in the Orlando area. Today she's going to be speaking to us about writing an effective summary judgment motion and defending. Jamie, welcome.
Thank you.
First of all, what is a summary judgment motion?
A motion for summary judgment under Rule 1.510 of the Florida Rules of Civil Procedure is where you ask the court to rule on either a case dispositive motion or discrete issues in the case without it going further or without it going to a jury.
Okay. When would a practitioner want to file one of these?
Although I've seen practitioners file them right away, which makes no sense whatsoever, you normally want to file them after the facts have been developed. With a motion for summary judgment, the court cannot grant it if there are any disputed issues of fact. So you need to get all your discovery done so that you know what there aren't disputes on, at least factually, and then you can ask the judge to rule on something on the law.
So at what stage in the litigation should you actually go ahead and file that, or does it vary?
It varies per case. I think it depends. If there's an insurance coverage dispute, normally the parties are going to move for summary judgment once the parties exchange documents and maybe a few key witnesses are taken. In a negligence case, say an auto accident or something like that, number one, it's going to be rare because there are a lot of factual disputes in those types of cases. But if there's a particular defense you want to raise, like we didn't own the car that was involved in the accident, you do all the discovery that can prove that fact, that it can't be disputed about, and then you move on the legal issue.
Other than discovery, is there anything else a practitioner should be looking at doing before filing a motion?
Well, of course, I'm a big fan of research, so I always recommend research. But in order to ask a judge to either throw a case out or to grant your motion on a defense or an affirmative claim, you need to know what you have to prove to the court. What are the issues that must be established in order for you to succeed? So if, for an example, you're a defendant and you want to argue the case was filed outside the statute of limitations, well, then you have to figure out what the statute is, so you've got to research it, and you've got to figure out what facts establish the statute of limitations and whether it was filed in time or not. So you need to know that in advance. You should know and do all the research about your claims at the beginning of your case, not at the end.
Okay. This is important for a lot of attorneys. How do you actually set the motion up?
Okay. I have seen summary judgment motions that are just written, there are no disputed issues of fact, we're entitled to summary judgment as a matter of law. I've gotten those before. They're difficult to defend, but worse, it's harder for the judge to grant something like that. That's impossible. I've even received them with complaints. You know, I get the complaint and a motion for summary judgment. It makes no sense. If you really want the judge to consider it and possibly grant it, number one, you give the judge the standard, which is Rule 1.510, and maybe some case law that talks about the standard for summary judgment. Most people know you can't grant summary judgment when there's a disputed issue of fact. What most people don't remember is it's a disputed issue of material fact. So you need to let the judge know that, because oftentimes the best way to defend a motion for summary judgment is just to say, there's an issue of fact, there's an issue of fact. Well, if it's not material, he or she can still grant summary judgment. So set it up for the court so that they know this is the standard, this is the law on what you're asking them to rule on, and then here are the facts that aren't in dispute that allow the court to rule my way.
Okay. Is there anything to watch out for in filing a summary judgment?
The biggest mistake I see as an appellate practitioner with summary judgments is trying too hard. You can win a case on one issue. So to suggest that there's no issue of fact with anything else, you're basically giving up the farm for the other side to file a motion for summary judgment that you've now said there's no issue of fact in this case. Well, that's crazy. If you have a defense, say the statute of limitations, and you argue there's no issue of fact related to that defense only, not the whole case, but that defense, then you have a better chance of defending an opposing motion for summary judgment on a factual dispute.
So you can limit it to something that is a dispositive issue, such as the time limitation.
Yes, and you need to be very particular, because I have handled appeals where the appellate court has said, given the other side has conceded that there were no issues of fact, summary judgment should have gone the other way. That's dangerous. You can't be so aggressive and overzealous that you're giving everything up just because you want to win. It can go the other way.
Okay.
So you got to be careful.
What about any tips on defending a motion for summary judgment?
The key thing is to present the material issue of fact. And you need to establish it. It is not enough to defend a motion by for summary judgment to be a lawyer that walks in and says, Your Honor, there are issues of fact, you can't grant it. The judge is going to expect you to prove where that issue of fact is. The rule provides for affidavits to be filed in opposition. I highly recommend that. Don't save it for the hearing. Don't think that you're going to carry the day at the hearing and suddenly start throwing things at the judge and somehow you're going to win that way. Be prepared to defend the motion for summary judgment in advance with your own memo in opposition and your own facts in opposition. That will help you, and that will also make your record for appeal.
That's for defending. What about when you're filing the motion yourself for summary judgment? Anything else you should file along with it, or save it all for the hearing itself?
I would never just save anything for the hearing. We're not as good as we think we are, and to think that we're going to say everything that's important at this hearing. File it in advance, give the judge plenty of time to review it. Judges want to read what you send them if you give them time to do it. So your motion for summary judgment, the rules provide when it has to be filed. It has to be at least 20 days before the hearing. File it 30 days before the hearing and give it to the judge 10 to 15 days before the hearing. Give them an opportunity to review it. Get your facts lined up, and if you can even get the other side to concede that there's no disputed issue of fact on this issue or that issue, then file stipulated facts for the court. You'll find that will happen in insurance coverage disputes and things like that, where you're just fighting over interpretation of a policy. Oftentimes the parties can agree what the facts are, and you just want the judge to decide, A or B. You can make it easy for the judge to make the decision.
All right. Any other parting tips that you would have?
I would know the rule. I would do some research. Again, big fan of research in advance. But you can set up your case for summary judgment if you're going to know what you have to prove at summary judgment before you go to depots, before you request documents. If you know what the 4 elements are in advance, you can set up your case to get there.
Right, and that starts with preparation from the very beginning.
From the very beginning.
All right, well, Jamie, thank you so much for being here, and thank you for watching this video on Mentoring with the Masters. Do check back to the library of our videos on a regular basis, as we're constantly adding videos. Thanks again for joining us.
Thank you.